Clear. Well, these are dates filed yesterday. There is some urgency. Can it be tomorrow, man? Regarding no confidence of a municipality boardman. Public. You matter. मैं तो मशरूम रखती हूँ तो इसके अंदर में तो फिर पहले लेकिन जब आइटम नंबर फोर Let's go back to mention for listing of a petition for admission number. Any date, registrar, registry, all matters go to the registry. Public. Why? Huh? What is the matter about electricity? APTC, why have you adjourned, keep on adjourning this matter? Huh? I have taken the consent. You might have taken the consent, but the consent has to be approved. By maybe 6 months after 3. You mean item 17, item 10, item 10. So I would hope you get the recorded for some. Here for who? Here for so here for the APTC. The records are not received. On the prayer for adjournment made by the APTC state council, something that he has not been given the what is the matter after 2. Huh? 22nd July. Huh? Yes. Why? Adjournment prayer has been made on behalf of Dr. A. Todi, that not for the benefit. Accordingly, this is matter after the prayer. Give me enough, I think. What is this? You left some judgment and you're giving me. Okay, you give this, give it to me. Like, let me Mr. M.H. Laskar, Learned Counsel for the petitioner, submit that the petitioner's contractual dues amounting to 1,29,47,928. Returnable in 4 weeks. With D. Jain accept notice of the above. Okay. All the sponsors. All the sponsors. Fine. Okay. According to this, to enable the response to file the budget. Loan bidder. Huh? The loan bidder. Loan bidder. Loan bidder. Okay. So the it's just contemplating what to do. What to do with the loan bidder. For either right. Presidency or get you take a decision. Get that decision. Because you have got the authority. If it's a loan bidder, then you can always go for a price tender. Yes. But if you want to give it, you depends upon that decision but so what we'll do is we'll dispose of this writ petition with a direction to the respondents to take a decision as to whether they want to take the NIT to its logical conclusion or to or, or to call for a fresh tender uh, within a specified period. Because we are the loan tenderer, that's what it is. Loan tenderer. Senior. All your senior. All your senior. Yes, I don't think I need password. Yeah, for who? Yeah, for the respondent. Yes, respondent. I'm planning to discuss it with no one. Petitioner, yeah, you have spoken to the petitioner? No. Right. No one appears for the petitioner. The matter pertains the non-payment of printing work done by petitioners number 1, 2, 3. The cause of action of all the three petitioners are different, as they have been given different, they have apparently been given different work orders. However, no work orders have been annexed to the petition. There are no particulars like specifics given by the petitioner to show that the petitioners are liable to be paid their bills for the printing work allegedly done by them. The absence of specifics it is difficult for the court to take a decision. Besides there being three different causes of action. Be that as it may, in view of the absence of the petition of the writ petition defense or not possible. Mr. H. H. Fully, KULI, appears on behalf of the AII. The AII, are you learned counsel for this? Two wins, point number 2 in front of the. Yes. What this order is based 42 start with the relevant part is there start from here 46 paragraph 10 11 12 13 and 14. So they have taken a decision. They have taken a decision that they want a higher revenue. So that is why they are asking for a. And that is not my case. My case. I know your case. That is their case. I can't be so now what do you want? So that is what they have said. Now they said that they want a higher revenue. What is wrong? They think that the revenue that you have offered is too less. That is not my guess is as per close weight of that. I know because
Osman Ali has not talking the cannot
I
from the
agree.
Kolkata. Yes, sir. Lordship set aside the settlement order and directed the respondent authority to shall consider respondent shall consider the state respondent shall accordingly consider the case of the petitioner for settlement of the dispute. As a field for it, the state respondent shall take a turn of the direction within a period of 50 days. Instead of settling the creditor with the petitioner measure, respondent authority measure on 23 25 million.
You file a short affidavit. Okay, file a short affidavit. Then we'll decide them. All right, Mr. A. Ahmed. A. M. Ahmed, learn pass for the petition. Take the notice, returnable in 2 weeks. Ms. M.D. Bora accepts notice on behalf of all the respondents. He submits that he will file affidavit within 2 weeks. This is the matter of.
I got it. In the meantime, my lord, tender 26 final statement. Otherwise, my lord, matter is
Any settlement out of the tender is subject to the outcome of it.
Uh, 17th is the last day.
yes, the largest.
Notice 1 week. 1 week. Then he submit affidavit within a week. Today is what day? 10th. No? This is the matter on 17th. This is the matter on 16th. This is the matter on this is the matter on 17th. This is the matter on 7th. So this is the matter on 17th. We take it out.
Keep the update.
Yes, what is your case? Huh? Huh? Yes, I'm taking it up. Tell me. What? You argue the matter. Oh, German.
I can make
Yes.
this matter is
How many petitioners are there? And how much is the petitioner number 1 claiming? Petitioner number 1 is claiming how much?
number 1.
There is nothing about what happened. You just tell me one thing. There are 3 writ petitioners, 3 and they all are all doing different work orders. Correct? Your claim is also all different. Correct? Show me your work orders.
Can be
Show me your work orders, Mr. Counsel.
I went to Kodingo and that I have
Sorry. No, Mr. Counsel, this is the third time this case has been listed. This is the third time this case has been listed. And in these, today is the third time. And yesterday also you had asked for time. Now, 3 times they have been listed. No.
I'm submitting. I have to submit to my.
What is your name, by the way? What is your name? Right, HR. So the learn process for the petitioner.
I'm submitting.
Yes.
First order enacted 2 months.
Look, I'll tell you a simple way to do it. Very simple. You withdraw this writ petition. You file 3 different writ petitions, giving the work order issued to each of the petitioners. There is nothing here. Nothing here. Mr. Learn process for the petitioner says that he may be allowed to withdraw the writ petition and file 3 separate writ petitions. By incorporating the different work orders issued to the different 3 writ petitions in the new writ petition to be filed. Mr. Smith did that. Appeals for all the response. Appeals for point number 4. While Mr. That other one, appeals for point 1, 2, and 3. The prayer of the petition council is allowed with petition dismissed because come on with liberty. On the last located lots, the directives are stopping the specific period for which each IHL which is capable. To that extent, we have received the instruction for. I'm sending over a copy. As per this instruction also towards the needy portion. It is for with effect from March 21 to May 26. And the amount payable is paid tax. Five thousand is for the photo. Down below it is reflected. The very big thing. Very, very big. It's number two. So it is for this period. So that period is all. Well, your is April 21 to March to May. So this is up, so they have admitted up till May 20. May 20. That was my claim. March 21 to May 20. Your claim? That was my claim was from March 21 to May 20. No, your claim was till March 22. No, no, till May 20. Where? The clear part of it. In page 14. From March 2021 to May 2021. To May 20. But now this last order that I have typed, that we have typed out, I have said that this March 22, where have I set this from? Also because they had filed the answer okay, they've given a different loan. Your claim is for this amount only. Lordship, my claim is from March 21 to May 20. For this amount. Yes, what is the amount claimed? Lordship, I did not claim the amount. I preferred RTI. Claim amount was 6 times. Lordship, may kindly have ordered it 8-5. That will clear the 8-5. That will clear the picture, Lordship. So their file affidavit is giving different figures. Correct. Heard Mr. S. Mitra, learned counsel for the petitioner. Mr. R. Talukdar appears for the respondent number 2, 3, and 7. While Ms. S. Barwa appears for the respondent number 4 and 5. Mr. S. Datta appears for respondent number 1. While Mr. A. Chalia appears for 6. Respondent number 6. The petitioner's prayer is for payment of his vehicle hire charges relating to forced traveler bearing registration number AS01 KC-5541 for the period from March 2021 to May 2020 by the point number 3. The point number 3. By the point number 3. Yes, sir. The affidavit of the respondent number 3 the effect that the petitioner is liable to be paid vehicle hire charges amounting to rupees 36,62,220 for the period from March April 2021 to March 2020 and rupees 17,41,248 for the period from April 2022 to September 2020, thereby totaling rupees 54 lakh approximately. Not the our thing. It was the total amount. That's what I said. The affidavit of the respond number three. Document I think if you look at paragraph 8 of, there is also it is reflected as 12 lakh. On the other hand, para 8 and 9 of the affidavit filed by the respondent number 3 shows that the respondents have admitted that the petitioner's outstanding amount is have admitted that the outstanding amount payable to the petitioner is rupees 12,05,874. This was by order taken 22/5/2025 and directed Mr. R. Farooq, Burnham Council for the respondent number 2, 3, and 7 to obtain instructions as to the specific period for which payment was to be made. So for which for which rupees 12,05,874 was to be paid to the petitioner as vehicle hire charge. Next one. Mr. R. K. Talunda, the learned counsel for the respondent number 237 has submitted letter number EHZ /27/2019/757 dated 23/5/2025 issued by the Office of the District Commissioner of Golpara and an attached statement of bill, of pending bill of the petitioner's vehicle, which is to the effect that the outstanding dues payable to the petition is rupees 12,05,874 for the period from March 2021 to May 2020. The letter dated 23/5/2025 issued by the Office of the District Commission along with the annexing made a part of the record or part as annexed collection. In view of the respondents having admitted that they are liable to pay rupees 12,05,874 to the petitioner, the respondent numbers 2, 3, all the respondents, all the respondents are directed to ensure that the payment of the admitted amount is paid to the petitioner within a period of after it is take it to court. We will give you just in case we need. Within a period of within a period of 4 months, within a period of 3 months from the date of receipt of a certified property. This petition is accordingly public. Yes, so he has said that you are the sole bidder, sole tender. So they want to take a decision as to whether they should take the NIT to its logical conclusion or re-tender the use. So let them take a decision within a specified time period. Let them take a decision. I got the information. There is another case pending around out of territory. Oh, WPC 6584 2020. WPC 6584 2020. 2020. So we tag it. Tomorrow? After tomorrow. Right. The series. Okay, anyway, take it up. Okay, Mr. Um, P. The Karma Planet Council for the Fisheries Department submit that there was only one bid that had been received pursuant to the NIT dated 8/11/2020. And as such, a decision is to be taken by the respondent as to whether they would go for a fresh, will go for a retender or take the NIT dated 8/11/2020 with logical conclusion. So we also submit that there is another case pending in this court regarding the same fishery. That is WPC 6584/2020. List this matter along with WPC 6584/2020. Definitely. By order ticket, 2nd of May.
While, when it is expired, instruction is not further in 2025 or the case in Parliament, not clear whether the ration card to it yet. This date, but up to that file of instruction 27th of May 2020, says by the report that
So,
and the question. Himalaya Nagar.
EPS machine is issued to you. So the impugned order has to be set aside.
Because they are having more than
There will be,
numbers of the
and then they have to also be given the EPS machine. है ना? Right, Mister?
I am R Islam.
R is not current counsel for the petitioner. Also heard with you that appearing for all the. The case of the petitioner is that the petitioner number one was issued a fair price of dealer license, correct? The year 1998, while the petitioner number two was issued a fair price of dealer license in the year 2008 for running fair price shop. The petitioner's grievance is that while other dealers, while other fair price shop dealers has been given EPOS machine, E small b, POS, POS devices. Right, it is the EPOS device, uh, good comma, point of sale device, point of sale, good comma. The practitioners were not given the same. Further, the respondent number 5 issued the impugned order dated 21/9/2024, tagging the ration card holders of the petitioner with the fair price shop, with other fair price shops on the ground that, what is the ground? Equal price. On the ground that the petitioners were not given the EPOS device. That's all. Nothing about 50 or less than 50, nothing. Next. The petitioners counsel that something. That when the petitioners have been having ration card holders above 50, there was no occasion for the respondent authorities to tag the ration card holders of the petitioner's fair price shop with other fair price shops. Next up, Ms. Yudas has submitted letter number TSF full stop 1 full stop 2025 /159 dated 27/5/2025, issued by the Assistant Director. What is this? PPT? Issued by the Office of the Assistant Director, Food, Public Distribution and Consumer Affairs, Gosaigaon, which is to the effect that he was convinced that both the petitioners possess more than 50 ration card holders, and it was probably due to technical difficulties of communication gap that all the ration card holders of the petitioners have price of had not been updated in the ERCMS portal. Next one. If you the submits that in view of the above letter dated 27/5/2025, the impugned order dated 21/9 359 2024 could not be completed. Correct. Next. I have perused the contents of the letter dated 27/5/2025, issued by the Assistant Director, Food, Public Distribution and Consumer Affairs, Gosaigaon, Government of Assam, Gosaigaon, which states that, which shows that, which states that the petitioners fair price shop had more than 50 ration card holders each. The said letter dated 27/5/2025 is made a part of the record and marked as a dictate. Next part. In view of the contents of Annexure Act, it is quite apparent that there was no occasion for the state respondents to have attacked the ration card holders of the petitioner's fair price shop with other fair price. And there was no reason not to provide the EPOS device to the petitioner. in view of the above reasons, the order dated 21/9/2020, issued order dated 21/9/2024, passed by the Assistant Director, FPD and CA, of the Tiger. Hereby seconded. The respondents are accordingly directed. Second card holders of the petitioner, step by step. And they are also directed provide the petitioners with the common point of sale device, practice POS device. Immediately. The repression accordingly. Allowed. That's all. I said immediately.
But I will want to do it, I will not do it.
Did you ask for what with?
Apply.
May I have a look at order dated 3/6/25 minutes. Page, order dated 3/1/8/05. Indeed. The respondent product. You are for respondent number? Nine. Who is eight? Eight. Then who is nine? Nine is the dealer. From whom we have taking one of the petroleum product. But you are the one who is having a petrol pump or what? Petrol. What's the order? Just a minute. Shall not be located within a radius distance of 50 meters from the field point between the nearest from schools, hospitals, and other residential areas designated as per local law. Now, for the case of consent question, preliminary of this. Let us see the law, what does it say, the consistent law, therefore, this is the preliminary observation that is allotted of date. Is the ambit pension law. That is what exposure. Let me see the law which says that it should be of petroleum. Petrol pumps cannot be installed everywhere, but it allowed to be installed by the authorities everywhere they are. There are certain guidelines, there are certain routes. Let us see that. See, page 27. There is a office memorandum where the norms. These were subsequently by not be directed by the district court to be speaking forward by the parliament. So we may have possible answer. Yes. Lordship may state to it. There is also 32. That makes my case 32. It depends. Okay, also may have any front page office memorandum. And page 27, guidelines for setting up of new petrol pumps in compliance of honorable entity. Then my lord, last part, last sentence. Final guidelines prepared by excel committee are hereby circulated for implementation by concerned stakeholders. Guidelines are hereby issued the approved the competent. Now, Lord, to make up to page 32, clause 8. It will be relevant for us. Clause 8. In case of city, criteria for petrol pump new retail outlet shall not be located within a radial distance of 50 meters from fill point, dispensing unit, and pipe, whichever is nearest from schools, hospitals, and residential areas designated as per local. So where is hospitals and other things are located, my lord? It's 50 meters. In case of conflict in providing 50 meters distance, the retail outlet shall 50 meters and 50 meters by peso. Who is peso? What is peso? Peso means police, explosive. Huh? Yes. That petroleum explosive. What do you mean petroleum explosive? What is the full form? Yeah. Petroleum and safety, petroleum and explosive safety. Petroleum and explosive safety. That is PS. That is the full abbreviated word PS. Safety organization. Yes. Which is in the rules for it. Okay. Now next sentence is important, clause 8. In no case, the distance between new retail outlet from schools, hospitals, 10 feet and above, and residential areas designated as per local. Where does it say in no case? Where is that word in no case? Where is that word no case? After peso. After peso. Okay, in no case, the distance between new retail outlets, schools, hospitals, and residential areas. And residential area designated as per local law shall be less than 30 minutes. Okay, so my case is this one. It is a revenue village. The instant village is called Sapolmo village. It is in Bonga district. The revenue village. And I'll show that my lord. That for under the revenue. Starting. Then my lord, what happened? Under the petroleum law 2002. Relevant provisions mentioning about authority to issue NOC, no objection certificate, for granting license and their competent power of jurisdiction have been spelled out. Also may have a look at the rule. It is the deputy commissioner. Which rule? My lord, the rule is the petroleum rules 2002. Yes, which provision? Rule, my lord, I will refer to that. Rule 21, within better room, Roman 10. Rule 21. Roman 10. Rule 2. District authority. Yes. District authority. Means, my lord, in town, the commissioner, police commissioner, in other place like us, the district magistrate, that is, my lord, the deputy. The authority, my lord. And he is the authority to, my lord, the certificate which is lawful by page 62 of the book, rule 144. Yeah, okay. 141. No objection, sir. Page 62 of this. Yes. Madam Mary. No objection certificate. Where the licensing authority is the chief controller as the case may be. An application for new license other than a license form so and so shall apply to the district authority. So we fall here. District authority with 2 copies of the site plan showing the location of the premises proposed to be licensed for a certificate to the effect that there is no objection to the applicant receiving a license for the site proposed, and the district authority says if sees no objection, grant the certificate. Meaning there, right? If someone applies for setting up of a petrol pump, district magistrate will have to see that there is no objection. So in this case, I being the person living in the adjacent plot, filed an objection. What happened? Objection dated? This to petitioner, my lord, the father. Adjacent land. Adjacent land. Certain activity. Immediately we filed an objection to complaint before the deputy. Another complaint to the direct controller. When? At page 21 and 22 year occupant. Page 21. It was to the deputy commissioner. I went to hereby want to inform that construction work of the petrol pump has started. The land nearest to my home, where the distance from the previous pump to my home is less than 2. Petrol pump causes air pollution, causes death risk. As the area is residential, I have diabetic, hypertension, 6-month-old baby and all. Further, I would like to inform you that neither nor my father have signed any NOC. We have not given any NOC for installing. Therefore, I request the planning to look into the matter of the construction work and relocate the petrol pump to any other location if any NOC provided will and payment for. Kindly consider that document as a false document. If you find that there is some NOCs placed before you by my father, this is considered this is not correct. We have never given it in. Then on the body of the petition, there were certain notes given by the deputy commissioner. He writes to the ADC and it, considering the case, NOC may be reviewed as per law and regulation. Where is that? On the body, my lord, connected 21, on the top, my lord, and it is ADC. That considering this case, NOC may be reviewed as per law and regulation. On my objection, on the same day. Maybe a few days later.
So when did they complete the construction? When did they complete the construction work? They're not there.
I'll come. And on the basis of the NSC, which is impugned,
So that is the basic case. That it can, that it cannot be less than 30 meters. That is the,
there is a survey report as directed by the deputy commissioner, Lord may come. We have given copies to the, represented to the pollution control board also. Then ultimately I was called for hearing by the deputy commissioner. Now, once that president, although initially my lord issued an NSC of subsequently he says no, there are various people of page 24. It was by the president of the Upper Muk now Panchayat. Objection against setting up. With reference to so and so. I so and so support of as per request of the respondent number 9, who wants to set up as per request of the respondent number 9. No exhaustion certificate number was issued for installation of oil pump. That number, pata number 12. I also want to inform you that I have received many objections against setting up of the retail oil pump outlet in the location from many people, including the residents of adjacent. In addition, I also want to inform you that I have personally
Okay,
visited.
so basically, this is the long and short of your case, is that the petrol pump is going to be at a distance less than 30 meters, which cannot be done.
And
That's
there is
enough.
a report.
Where is the report?
There is a report by Annexer 5, we were called for hearing, we attended hearing and we
Page,
page 25. Page
that is for the report. Where is the report?
The report, my lord, the deputy commissioner directed the circle officer to conduct a field survey and produce the report whether it is 30 meters or not. That report your lordship will find at page 26. So that's per direction of the deputy commissioner. I am reading it, madam. To the additional district magistrate, it's deputy commissioner. Submission of report connection with setting up of new petrol. Reference to, I have the honor to state that as per order and written instruction, dated so and so, a joint survey notice was served to Sitaranjan, that is me, my lord. Applicant Bimal Prasad, response number 9, and representative of the Naira Energy, response number 8 and 9, my lord. 8, as per which field survey was to be done on so and so date. However, it was informed that response number 9, they cannot be present. They said that they cannot be present due to representative of Naira Energy could not be present. After that, due to flood situation in Roha, survey could not be agreed. Its survey was again fixed on 10/6/22, but on that day, survey response number 8 site informed that they cannot attend. It's on the 2nd April. Constitution they failed to come. The present at the survey, not a representative of energy which was needed as their engineer prepared the site map. So there was non-cooperation by them. They were given one term from the 2nd day. So the public over, they were again called, they again. Now, my lord, however, the field survey, sitting center, first, however, the field survey was undertaken with concern Latmandal, representative officers, public officials of PWD, Sri Sitaranjan, me, my lord, my father, Gaon Pradhan of Kaparmukh Gaon and the landowner. Following were the findings during the joint survey. There is no school hospital at a distance of, that is correct. The distance between south of the land bearing that is my tag number and pata number, which is in the name of Yogeshwar Bora, petitioner number 1, son of God, to the petroleum pump unit as mentioned below. Now see the finding. This point to Yogeshwar Bora's house is approximately 12.31. Talked about less than 30 meters, hill point, and dispensing unit is also approximately 16.5 meter and 15.53, less than 30 meters. Then number 3, vent pipe, whereby there is mile of petrol through the pipe or pour to the mile of vehicle. That point. Vent pipe to house is approximately 7.8 meters. So clearly, there is no high tension. Clearly against the guidelines, far less than 30 meters of report submitted by the circle officer to the deputy commissioner and by all competent.
Only one thing I want to know, this residential area designated as per local law, what does it mean? What does that?
Then my lord, after for several months, my lord, no activity there. After this field survey report, no activity there, no work was, my lord, after this. However, we sought for deputy commissioner, what did you do after this? That was not never disclosed to me. It was filed an RTI for that. The deputy commissioner, the RTI is at my lord, page 33. Yes, page 33. Then page 34. Application for the forward DC permit submitted to state regarding RTI petition. Then minor page 35. whether he has issued any NOC, he was not informed. Ultimately, we went to the RTI Appellate Authority by page 2024. Yes, 2024. Appeal under section 19 of the RTI. Then my lord, the reply came in 2024, 3. And then we came across the form and NOC order issued by the deputy. Kept it hiding for about 1.5 years. We go to his office, he doesn't say that NOC has been issued. We had to apply for under RTI. That was also not given. Anyway, now it's given. Anyway, now my lord, ultimately my lord, this was given to us, which your lordship will find a big party. Yes, NOC, it is the imperial, it's the basis for granting all such. Is what we. Yes, my lord. Kindly see this order I am reading, no objection certificate, with reference to application of so and so, issued from so and so, in pursuance of 144 of the Rule 144, which I have read, my lord, Deputy Commissioner, power to issue NOC for storage of petroleum products, tag number, patta number, enclosed here it is doing. The following particulars have been considered while issuing no objection certificate. Possession of the site of the applicant is lawful. It's all right. He has taken on leave. Interest of public, especially the facilities like the school hospital, proximity of the place of public assembly and the magnitude measure, traffic density, conformity, accessibility, genuineness, any other. No whisper and no mention about the public. No whisper in this. All about public assembly, but when my courtyard file, there may be, okay, Mr. I've heard that. So that's not waste time. What is that? It has no whisper, my lord, not taken into consideration. The deputy commissioner himself having directed the to make a big survey and he will report. Okay, so basically the no objection certificate, it is citizen. So therefore. So, yes, let us hear the other side. Is there anything else you have to show me? The district magistrate was also directed that they filing. Let me just file, let me just refer to the my lord, that supports us at one place. Can you wait? Either way. Yes, they are affidavit by the page 66. Yes. It's by the page. Going through revenue cycle, they talk about environment that talk about. Okay, a single house has been found. That is my house. There is another affidavit I will show. Another house is also there, which also falls under. Anyway, so the issue is that residential area required to be one house or 20 houses or 50 houses? That is not necessary. So which, let us hear the other side. Plot wise might not be plot wise. Here and your house is already standing long time. Already standing for 10 years, there is a certificate. Let us see. Yes. Look, मतलब ये बहुत की वन करेगा at page 15 करेगा page 15,000 करेगा yes. The practice that the department of mention gains the construction work for the setting of the the pensioner could not approach the unknown post sooner into the pension number 25 in health and as per delay in approaching the post hiding the And not delivered. The people have all been kept in dark about the thing and got now, yes, what has been developed? It has to be a lot what has been part of no further. But in first part of March, well, everything is topic. It was also see by IA at page 72 on us. A lot.
March 25, public.
Yes, public, my lord. And they wanted to, my lord, run the depot. At this stage, my lord, they come here. I asked him.
So you have an out of court settlement with him.
My lord, I am coming.
Give him free petrol every day.
My lord, that's a page 72, my lord.
Discount for life.
Yes.
Yes.
Page 72, my lord. Ah. Page 70,
There's a fifth page. Huh?
72, 73, 74, my lord.
No, I understand. I understand.
Now, my lord, what happened? My lord, he is house is not in the editor's office at that point of time. He was admitting to keep my lord. He wanted to convert the land from agriculture to resident. My lord, if the losses comes to page 75.
Page 75. Yes.
This is the my lord, the Jamawati. Now it was converted, my lord, only in 2024. Last chapter, people also see. Land of card number 12 from petty land. Petty land means, my lord, agriculture. From agriculture. From to first class residential as per approval given by the deputy commissioner for collection proposal for a district. 412.
Why order dated 4/1/24, 15/00/15. There be the time.
Yes, Malad, that is the Malad becomes a essential. As per local law, Malad, his house becomes a essential at the time. But Malad, my
And you started the construction in 2022.
22, and completed, Malad. It is completed. We wanted to bring the Malad petrol at that time from our petroleum products. At that stage, Malad, he came here and obtained an order. No further construction. Well, further construction, I have not made anything, Malad. It is complete, Malad. Malad. And everything, Malad, you can also see all the permissions I have taken from the explosive license, everything, Malad, you can also see. And page 57, Malad, you can also see, Malad, the President Town Panchayat himself has said, Malad, page 57 of this, I just keep, you know, the yes. That I have next thing I have
4/25.
yes, 1/4. Yes, please. And page 57, you'll also see, my lord. This time, part of my lord, he has
Page 57.
Yes.
Yes.
died.
How the, just a minute. Page 57.
My lord, they have taken most of it, that I have already.
Yes.
I have also submitted that. Presently in the interest of public, of the greater public, area, there is no objection of any type or purpose for certain of either side of the. Well, there is no petrol pump nearby, my lord. Everybody wants a petrol pump to be there, my lord. And I have taken from this certificate for everything, my lord.
He wants something. He doesn't. Maybe he wants something more than fresh air.
That's it. Well, if you're not, my lord, that
I don't know. You talk to him properly. You invite him for some chai or something. I don't know. Have a dinner or something. Might have a. That's it. So it looks, or maybe he wants fresh air, maybe not fresh air, something more than fresh air. I don't.
well, but the time of the hearing, my lord, at the time of signing of petrol, was not the residence area, it's the cultivable land, so the house, so that, my lord, has not applied. And after that, my lord, and their construction is going on. He knows everything. He has seen the house. My lord, he has come, my lord, when the construction is completed.
He's spying on your construction.
Approach and court passed an interim order, no further construction, but actually, my lord, because of that order, I could not start functioning. And partially it is interest of public, my lord, of that, everybody, nowadays in the village also, you're lost, my lord, the vehicles, enough vehicles are there.
Looks like a deserted place.
Then the place. So enough vehicles are there, my lord. Autos, four-wheelers, everything is there, my lord. Two-wheelers, they want petrol, they have to go by long way, my lord, to get a petrol.
Maybe-
That is why, my lord, take that to public.
Maybe you should give him some ideas, tell him to open a tea shop or something and then.
That we can.
Yes, so basically, his case is that it is not a residential.
No, that is, one thing is the question is not petrol pump. But the public. You are not even allowed to open a pharmacy right in front of my gate.
No, that is not the issue. The issue is simple.
That is not the issue, whether at the time of issuance of the, no objection, because there is residential and whether clause is applied to that, not prospect, not prospect. At the time of issuance of the penalty, whether my plot was created as classified under the local law as a residential plot or not, it's done. There, my lord, we should not be under any misconception.
Okay, so we have to see whether, so the question is, at the time of issuance of the NOC,
Yes.
whether the plot of land was residential or not, correct?
Yes.
Okay, now I'm just recording it for everyone's, thing. Just right. And the petitioner found the subject that the issue to be decided is whether at the time of issuance of the NOC by the district collector,
There was a residence or not.
the house of the petitioner was under a residential, was a residential land or not?
Both my plot was the land belonging to the neighbor.
No. Your neighbor is nowhere in the picture.
Including that plot also.
No, your neighbor is not a party here. Sorry. This is not a PIL, Mr. Council. This is, no, your neighbor is not a party.
Which one, my lord?
Is he a party, your neighbor? Is your neighbor a party?
No.
Then how can you, how can you? Huh? Ah, whether-
Then my lord, at the time of the big vote for that,
Ah.
whether my house was located.
Okay, that I will see.
That is, you can get it for it.
So I have recorded, that is correct. Whether at the time of issuance of the NOC,
There was a residence of mine.
there was, whether your residence was on land which was residential property.
That's what I
That's
want to do. As well as the land of the number nine. But it is not, it is not.
The Point number 9 is, has got nothing to do.
That land is also.
No, sorry, you just fight your case, don't fight for
No,
them.
no, no. That land is also residential. That land is also residential.
No, that is not the issue.
Portrait.
No, that's,
Portrait.
sorry, sir.
Anyway, come to my land.
Only your land, you stand on your own legs.
Okay, come. I want to. That. Foundation was resident. It followed. Up to 30 meters. From my land. That I had a residential house. That was. I had two sets of classified and I not. Not the family.
Okay.
For that. And that reclassification is done always clockwise. Always clockwise, not the area wise. Also kindly turn to page 52.
No, you see, your land,
Yes.
what is the, your property is covered by,
Showing my Dhamma Pundi. Showing, we have shown it. Let me also show my Dhamma Pundi.
yeah,
Page 75. It is mine.
this page 75 is your Jamapati. correct?
Yes.
Okay, I think I've heard,
Last number.
yes,
Last page. Page
Yes.
75, last column, last page.
yes,
Then the card number 281 of photo number is converted from petty to first class residential as per approval given by Commissioner to the correct proposal by further statement. That is one.
correct.
Then, my lord, affidavit in reply, I'm sorry. Yeah. Page 91, Lord.
Page 91,
Latest of this memorandum by government.
page 9,
We can follow.
affidavit in reply, it starts at 104,
Read to the deputy commissioner. Page 91.
91,
That's what it is.
page 91. Yes,
The state government to permit setting up of new petrol pump immediately as per certain criteria.
page 91, no. That is not the document. Page 91 of the affidavit of the respondent number 1.
In the read petition, our. In the deputy
In
commissioner.
your affidavit in reply starts from page 104. Oh, you give me your, what is the page in your affidavit in
Yeah,
reply?
connector one, my lord.
Annexure 1. Annexure 1, this is annexure 1. Affidavit in reply and on behalf of the applicant to the affidavit in a position filed by the respondents number 1 and 2.
Not in the IM, in the read petition.
Okay. Oh,
The read petition.
that's page affidavit in reply. Page 91.
Yeah.
There is no page 91.
The one.
It's a report.
Yes,
There's another document. Okay, this one. Okay. Yes.
Did the annexure then?
Yes.
It is that they are setting up of petrol pump.
Yes. Yes.
I would say, lesson gain beginning. And some people. Yeah, this is a problem. It's because of the. With respect to cases where no residential areas have been classified in the token law and where there are no non-planning areas under the token laws of the commercial zone PQ. And that was also the top question. Although I am Supreme Court has imposed on this big guidelines in the judgment that is correct to significant. There are some cities and the position for the code is. Speak according to CPCP guidelines. On the time to bring the following is recommended. This is to take up the method of classification of areas in the state under the extent rules, regulations, bylaws and implementation. Fitting criteria related to. Two is important. The state government to permit setting up of new petrol pump strictly as per fitting criteria, prescribed by local laws, is an unclassified area, non-planning area, big zone, commercial zone, taking into account the guidelines. That is clause 8, where clause 8 comes. Even in unclassified area. Even in unclassified area, if there is a dwelling house, they can never go and can be submitted, by Bhutas list. Additional affidavit, my lord. Okay. Kindly have a look. Step. Page 46.
Oh,
Page 46. Yes, sir. Yes. Okay, additional affidavit. Here your lordship will find.
page 46 of additional affidavit.
Yes, yes.
In the writ petition.
This is very important. Very important.
I will look into all the documents. Page 46.
This is with respect to page 46 connection.
Yes, page 46. Yes.
One of the left hand side, the name of the patadar is Santosh Singh and Sujan Singh Sab.
Patadar of whom? Of what?
Land of the my lord. Respond number 9.
How does that matter?
So here the petrol pump is 20.
So how does it matter?
Yes, it's better. Then it is. Petrol pumps cannot be allowed to be set up where it is residential. This plot itself is residential. Ready? Let's keep taking note of it. Kindly have a look at the below. Column below.
There.
The proposal for class modification dated 12/10/2020. The class, the recommendation given by Deputy Commissioner dated 12/10/2020.
There.
The class of land dark number 225, pattern number has been changed from agricultural to residential.
So,
That means by 2020, whereas in 2020, the land itself, where the petrol pump is now from them minority traffic only for water. Santosh Singh and
so where can a petrol pump,
Yeah.
according to you, be established? What type of land can it be established?
Extra classification for each day, as per local law. Non-residential,
Non-residential will include what?
non-residential will be on non-residential. And here, where it is 2020, this plot has by the
Can there be a residence in an agricultural area?
Yeah.
So there can be no petrol pump in an agricultural area.
There can be.
Is it?
But
You
there
you
must-
just said that in non-residential
But
area.
that must not be on a resident, that must not be on a resident. We are classified in that. There must not be a resident. Nearby plot
We
might be
go by the rules only. We won't go beyond that. We'll go by the rules.
Root says very clear.
That's anything else?
Non-agriculture, can have it. Good, you can go. Non-agriculture, less agriculture, less classification. Then, have a look at it. Or compartment. There can be a house, then after the 100 meters, there can be another house. Oh,
Four.
our definition for the
Oh,
section here, section 2. Section 2. ABCD is 4. Page 131.
yes, yes.
4. Non-agricultural class includes all trade sites, including industry, commercial, or residential sites. Therefore, it means that even in non-agricultural class, there may be residential site, important site, singular site. My house is on a site, area is an area, site is a site is smaller. Residential sites are included.
You see, it talks of
Then- then
non-agricultural, but yours is petty. Petty is agriculture. That's what it is.
It's non-agricultural class, includes all trade sites,
Non-agriculture class includes all non-agricultural land.
all trade sites, including industry, commercial, or residential site. I mentioned the document, I have to mark on all residential site. That means, even in non-agricultural class, there can be residential site, like this. And next, P. Non-agricultural land also means land other than agricultural land and intended to be used for non-agricultural purpose. Where am I putting? Now, Lordship may kindly see. Now I'm.
How much more time will you take?
5 to 10 minutes. Okay. Now, Lordship kindly see. In page 93. Page 93. Here are some photos. Right? Can I? What locations are there? What you will find? The dwelling house there. There's clearly a dwelling house, the adjacent petrol pump is there. And the tribal officer report says it is within 30 meters. That I have done. And now referring to the voters list of the Punjab, I have annexed one document at page 50. Our additional affidavit.
page 50, our return like this. So, we may have a look at page 93 and extra. 93 is of the government. Keeping the agriculture department, page 93, that they have. Page 90. Yes. Okay. Yes. The agriculture department. Yes. Yes. Upon joint verification, annexure one from agricultural development to future power, owned by us. Found that the above mentioned sort of land has already agricultural purpose, construction of building house for which it has become unfit for agriculture. Use of land has already been changed and for non-agricultural. That's my problem. So we cannot ignore this also. Then also from careful analysis by Downpudan, Downpudan is found that the plot of land has not been utilized for agriculture for the last 10 years. So my residential house is there for last 10 years. It is clear and that photograph. Yeah. Then my lord kindly see page 50, the voter switch. So it is it's clockwise line of class. Well, how I say. Clockwise, clockwise. Some are not classical. Sometimes it can be classical. But this is a proper plan. It's classified as proper plan. Of 2 figures, classified, then a classified plan. Non-agricultural plan. 350 miles.
So petitioner, 1 and 2 are living in the same house.
Living in the same house, here, house number 404. Can you have a look at it?
No, no, Mr. Council, we're just going around. I've heard there's nothing.
So
There's
mine
nothing
is
here. Heard Mr. A.T. Barbara, Leonard Senior Counsel for the particular.
All right.
Assistant, yes, yes, madam, wonderful. Yes. Heard Mr. A.T. Barbara, Leonard Counsel, assisted by Mr. M. Smith. Also heard Ms. Yudas appearing for 1, 2, 3, and 5, Mr. S.S. Roy for number 4, and Mr. Yes, Sahawala, Senior Counsel, assisted by Mr. M. Talwa for point number 9 or 8? 9. You're the petrol pump. Hearing concluded, judgment.
One picture I am setting that will.
Which para you want me to see?
It's written there.
10, 11, 12. 10, 11, 12 first. Guidelines are issued as, yes. Put everything. the other day. Yes. What is your kid?
So I look to airport is separate. So if I did work my in paper work.
Correct.
Mainly I'm relying on the judgment of maximum stability of file. So the domestic inquiry is not held properly. And there's no.
Domestic inquiry was not held properly.
Professor.
Why?
He has not given proper.
A proper opportunity.
Source examine the witnesses.
Huh?
Source examine the witnesses. By the time of domestic inquiry, there was no given proper opportunity of proceeding.
Have you taken that stand before the tribunal?
Not severe taken. And they have also not taken the preventive criminal issue in the tribunal that the domestic was fair, conducted fair. Mainly in the judgment, paragraph 36. Hmm,
Para?
36. Mainly I am relying on
Para 36 of what?
36 and 37 of the
Okay, of the judgment.
judgment. There it was stated that in 11 we will first consider cases where an employer has said a proper and petty domestic inquiry before starting an order of service. Previously, the tribunal had no power to interfere with the finding of misconduct recorded in the domestic inquiry unless one or other information is pointed out by the court. In an item versus state company, the conduct of the proceeding and the punishment to the infraction were all considered to be managerial responsibility for which the tribunal had no power to interfere unless the finding was the first or punishment was so has as to be to the interference of victim victimization of unfair level respect. This position, in our view, has now been changed to by section 11A. That the word in the course of education proceeding, the tribunal is satisfied that the order of the discharge or dismissal was not justified. Clearly indicate that the tribunal is now forthwith the power to reappraise the evidences in the domestic inquiry and justify itself whether the state evidence is relied on by the employer establishing the system of the what was originally a plausible conclusion that could be drawn by the employer from the evidence is now given place to the discussion being arrived at by the tribunal that the finding of the misconduct is correct. And in this family is now at liberty to consider not only whether the finding of this misconduct recorded by an employee is correct, but also to differ from the state funding feature proper institution setup. What was first clarity in the meeting, the aim of the satisfaction of the employer has ceased to be shown. And now it is the satisfaction of the employer that finally decides for them. In fact, in labor court that all the evidence were reduced and labor court proved it down. And in that time, they were not proved that no evidence is produced to be favor of management. And whatever. And in paragraph 37 also, if there can be no inquiry held by the employer or if the inquiry is held to be effective, it is open to the employer even now to edit the evidence for the first time before the tribunal. And if people end up before the tribunal, they have reduced all the witnesses and witnesses paid to the judge against them. This way, the judgment passed by the tribunal was correct.
What was the ground or the reason for the tribunal to make the finding? And what is the ground?
So they have
They are telling me the law. But I want to know the facts of the case. What are the grounds? What was the basis? What was the findings of the learned press?
before the panel process, they have reduced to 5 cases. That used to be duty process. And they could fail to prove the charges against them.
So, okay,
Government.
okay, but what was the findings of the tribunal?
Finding is what is in the last paragraph.
Eight,
Page 122.
122.
122.
Yes.
From the scrutiny of evidences on record, it appears the domestic inquiry is not in accordance with the physical and legal description also. Apparent from the evidence on record that the charges of instituted to the manager, theft, plumber bearing or any demand of money were not proved. And also the termination of workman on the ground of above charges which conduct are not justified. And also I hold that termination of workmen is not justified. From the scrutiny of evidence on record, there is no single feature that others to be termination of workmen. Therefore, it is entitled for that which is also. Within the state of workman, there is a state of sponsorship for the data. In support of the case, they often state with 5 issues. After that, it has a inquiry of an employer under the management. MW1, management number 1, in its post, it admitted the fact that there is no documents to show that notice dated 1/11/2011 was state to the workman. He also admitted that there is no endorsement of such. It was not given, Catholic was not participated.
Huh?
Catholic was not given to the workman.
That is wasn't given to the workman?
Really admitted.
Where?
MW1 is quoted, admitted the fact that there is no documents to show that.
Which
notice.
page? M1.
MW management
Ah.
system over.
Admitted that it's before that.
There is no documents to show that notice dated 1/11/2011. That is exhibit 12.
So what is that?
That is that they have stated that the casket of copy of casket was furnished to the working.
So it was not furnished to you.
No, sir.
Let us see what is the notice dated 1/11/2011. I don't believe that.
I'm page 59.
Page 59. Yes.
59.
Lockheed
Correct.
111, I'm extremely sorry, my lord. That is the letter which has been issued by the management.
Kuldip Singh Bedi, second Peter.
Just a minute.
I'm sorry. I'm extremely sorry.
Yes. Page 59.
59.
Yes.
This notice has been addressed to Sardar Kuldip Singh Bedi. But there is no endorsement, there is no such proof that that notice has been published.
Mr. Counsel, this is not the charge sheet. Please read the second line.
refers to the chassis that the 5/9/2011 and the domestic at head and before passing the final dose in the case, we are enforcing here with a copy of the inquiry of
The inquiry report,
Inquiry report,
it's, where's the question of charge sheet?
sorry, inquiry report, inquiry no. And filing that is.
So one is that there is no inquiry report. Why does the court say that the labor court, why does it say that the domestic inquiry was not in accordance with the principles of natural justice? Because of this inquiry report, not submission of inquiry report or what?
But it was not submit on the because of the- and further the witnesses also the second from the input from page number 121. 121. Marriage. Yes. From the second paragraph, from the scrutiny of evidence recorded, the present no document to come to the conclusion that the government is inquiry report. The requirement of law is that after conclusion of domestic inquiry, notice along with the copy of inquiry report which is sent to the agency. However, in the present case, management is paid to do so. Apart from the inquiry, was not an unbiased person. So the in such circumstances, domestic inquiry conducted by the inquiry is not proper. As regards to the case of charging of demand of right of for repairing machinery, the children is as well as supply of goods, the management has not examined the person from whom the bribe was demanded. Then the management, which is number 2, in close examination, admitted the fact that he has not seen the incident personally. Regarding the evidence extent of fact by the police basis, in the truth file, that is in the truth file, management with the 5 minutes was stated that he cannot say that he was detained in evidence of education. What was in the evidence of education? As it has the charge of entering the workman in senior manager office without permission and stopping the shop of the point by the workman. The evidence management decision was wanted the management, not supported by other present evidence. Rather, M.W. in this close attempts admitted that he has not seen an incident personality regarding the arrest incident. He also stated that he knew about the arrest demand to the supplier made by the workman only at the time of reporting domestic income. He also admitted that he did not have any personal knowledge about the demand made by the workman. The prior nothing substituted by the management.
Some water. Yes. So
Yes.
basically, it says here, one is that with regard to the inquiry officer being an advocate.
Lordship, please.
Okay, that I think the Supreme Court judgment has taken care of.
Yes, my lord.
Because if an inquiry officer can be an officer on the payroll of the employer, a lawyer who may have worked for the management and who is not on the payroll of the thing, why should he not be said to be? How can you say that he cannot be inquiry officer?
No.
When you allow a officer to be an inquiry officer, why not I do? Now, number two is whether the labor court has said that there is no document to come to the conclusion that the workman received the inquiry report.
Lordship,
Now,
please.
with regard to that, of course, though the petitioner has taken a stand that there is a letter 1/11/2011. Where is that 1/11/2011? 59. Page 59. Let's get this page 59. Anything else? What else? Nothing. Yes.
My lord, on the last occasion, I had in fact pointed out, my lord, that the ground that they have taken, that the inquiry report was not served to them. I have said that the letter was issued, but no opportunity was granted to me.
Volume.
Yes, my lord.
Huh?
I said that, my lord, the letter which I have issued in regards to the inquiry report
You have said
was
what?
was not received, my lord, by the employee. In that front, my lord, that question came up for the first time only in a cross-examination. He has never taken that defense either
Okay.
in the statement before the labor court, nor he has raised that objection before that. So that question was only put to me in a cross-examination. I could
No,
not have.
be that as it may, the
Yes,
labor
my
court has now taken a decision on that.
grateful. Yes, my lord.
Be that as it may, the labor court has taken a decision on that.
Yes, my lord. The only thing is,
Can this court now reappreciate the evidence?
my lord, all I'm saying is that he is not, that whenever an inquiry report, as important as an inquiry report, is not being shown to him or not been produced, he has not been able to produce anything to say that he has been prejudiced by that. So unless and all that he is not being prejudiced, we'll have to accept the fact that the notice.
No. You see, that is not the issue. You see, the question of prejudice
My lord,
will occur only with respect to notices,
right, my lord.
not with regard to an inquiry. Inquiry report has to be furnished. That is
That
that is a mandatory requirement.
under law,
That
the notice
those
was
judgments
issued, my lord.
that you may refer to
My lord.
are pertaining to probably notices issuance. On all cases, notice may not be required to be issued when there is no prejudice caused.
No,
And
but in this
unless
case, my lord, with all due respect, the
no,
notice was
but in
issued,
this,
my
you
lord.
see, the issue is not, you see, according to me,
My lord.
you have to issue an inquiry report to the
Yes, my lord.
delinquent officer or to the workman. And if you have not issued, then then the entire inquiry will fail.
My lord, with
Now,
all due respect, the
the
notice was issued. He says it was not received. That's his allegation, my lord. The notice has been issued, has been exhibited at Exhibit 18. Unfortunately, he said it's not being received.
Your voice is breaking and your
My lord,
yeah.
I'm extremely sorry, my lord. I am not being able to be myself present. My lord, can I request it to be kept tomorrow? I'll be back today. If it is not inconvenience, my lord, I'll just take 10 minutes, my lord, tomorrow. Hello.
I think we'll discuss on other day.
My
The
lord,
issue is simple.
yes, my lord.
Okay,
Can it be
right.
on Thursday, my lord?
No, I don't know, very full. Thursday we have got the bench. 'Time. 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 'Time.
I leave it to you, my lord, whatever is convenient, my lord. But actually, I'm not available next week. Any date convenient after that, my lord.
Okay, we'll fix a date whenever you're free.
I mean,
Why don't you pay the wages?
my lord, in fact, in that I have already said, in regards to the wages, my lord, I have already sent a email. I'm awaiting instruction on that, my lord.
You obtain instructions by the next day.
My lord,
Huh?
my lord, I'll do that.
Okay, right. List the matter. When give it in. After the vacation. Okay, no time.
After the vacation, my lord. After the vacation, any date, my lord.
17 July.
17 July, my
By
lord.
which
17
date
July.
the respondent shall obtain instructions, by which date the petitioner shall obtain instructions as to why petitioner's counsel, as to why the wages of the petitioner respondent workman has not been paid.
Extremely grateful. I'll do that, my lord.
Okay. That's the problem with having workers, that you can't hear them. Item? Okay. I am not on that. I am only on the issue of whether the decision of the labor court, whether the labor court had the competence to pass the award. That's it. There's no point going into the facts of the case when the preliminary issue has to be decided. That's it. Yes, yes, I'm giving you.
But where the temper changes the condition of practical, then it's industry. Like from my way of the judge says that
Let me write down what you.
9A.
based on the
Section 9A.
section 9 of the judge. Where is the condition?
Yes.
Okay. It's the
Yes, yes.
employer proposed to have and they took the act. The resistance proposed.
Are you a workman?
Yes, I know that.
Why? What is the definition of workman? Where is the award?
Avoid the state of an I think calculation of the word. Yeah.
Just a minute. Just a minute. If it is 1974 TSCC 510. Nineteen 74 TSCC 510. The issue is whether you are a workman. You are a sub editor. Sub editor, whether he's a workman. Let us see. Let us see whether a sub editor is a workman. Okay, whether journalist can be a workman. Who is employed in a managerial or distribution. What is your wages? As
There is also the family that is appointed to elaborate the process. That is the need,
Mr. Council, I didn't ask you what you ate for breakfast. I asked you, what is your wages as a sub editor?
wages. Depends on the house. Can use service to provide the different kind of wages, but that is a wage coming from which for marginal wage. That is specific accommodation and we implement. It's under the consideration of
Yes, what do you want to show me in this document?
so the state is paragraph that is one.
You see, I think 9A is always there. The issue is whether you are a workman. That is what I want to do.
I have a workman for section 2 here. So I need to allow this subject. So wordsmith means any person who can employ any even any manual of the technical, professional, medical, or supervisory work for hire or given. So that the tires of department can be expressed inside and for the purposes any substitute and the state is the basis that is speak. So, unlimited person, does discuss that good or bad, not good or bad, or good, does but makes the person, any person, who subject to the airport, I think that the also is subject to the airport, not the right. It employed in the food, but employed of that or other employed of the being otherwise who is employed or fighter capacity who wages at least 10,000 rupees for ransom for exercises cited with the method of to the first job or fighter instead of the powers on the negotiable rate party supported who was as a manager for the managerial nature then also managing is the work only the editor and the management become under the state.